And welcome back here to Live Now from Fox. I'm Andrew Kraft. Our next story takes us to Los Angeles. Well, the district attorney there, George Gascon, he held a press conference today, and it was quite shocking to a lot of us who have followed this grisly murder case. The Menendez brothers, back in the 90s, now serving a sentence, of course, for killing their parents. There's a very popular Netflix series about this right now. Well, George Gascon says that he will be reviewing this case here in the wake of some of these allegations that have come out about abuse at the hands of the parents on the Menendez children here. Now, that has been in the atmosphere for some time. It has come now to light in the wake of this new series on Netflix. So Gascon is saying, essentially, he will be reviewing the case from all angles. Now, famed criminal defense attorney Mark Garagos in L.A. is responding to this news Gascon made just about a few hours ago here. Let's listen to what he has to say.
Hey, are we ready to go? I'm going to wait 10 seconds. Where's ABC? Okay. Because supposedly you've got the feed. Okay. My name's Mark Garagos. Along with Cliff Gardner, we represent the Menendez brothers. I've got Brian Friedman here. Brian represents 24 members of the family on both sides. The reaction today by the DA is what I've been saying for the last basically year and a half. A year and a half ago, we filed a writ of habeas corpus. We presented two pieces of evidence. The one was a letter from Erik to Andy Cano, which predates the killings by 8 months. The other was a declaration by Roy Rosello, who is another victim of Jose. The combination of those two, we believe, provide more than ample basis to set aside the result of the second trial. For anybody who's been following this, you'll remember that the first trial ended with there were two juries. Out of those two juries, both of them voted more than half for not guilty on murder and were hung. By the time the second trial came along, it was on the heels, 8 days, frankly. Evidence started 8 days after the acquittal of O.J. Simpson. The rulings changed, even though it was the same judge. The prosecution changed, and frankly, they were deprived of what I consider to be a meritorious defense. They have now served 35 years. In that 35 years that they have served in prison, they've been model prisoners. They have worked tirelessly in the face of literally no ability or expectation that they would ever get out to reform not only themselves, but the environment they find themselves. There has been a sea change in California. When they were convicted, California was in the throes of a prison expansion, a law and order expansion, and frankly, DA politics. And now we fast forward 35 years later, we've got a much more robust and evolved understanding of abuse, that yes, abuse can occur both with females and with males. I think it's time. Their family thinks it's time. I believe that what you saw today with District Attorney Gascon was that he has taken, I think, a rather bold step in that he has said he's going to make the final decision. It's it may not be a popular decision in prosecutorial circles, but I would think that in our culture, we've come a long way in the last 10 years, maybe 15 years. I think we're at a point now where any reasonable person taking a look at this case believes they should be out. And based upon that, I'm gratified. I'm hoping that sometime before Thanksgiving, which is when the next the response is due, that they will either, the DA will either concede the habeas or join in us in asking for a resentencing. And I'll take a couple of questions and then I'll turn it over to Brian Friedman. And he's not here, but Cliff Gardner, who is my co-counsel, deserves a lot of credit, because anybody who's followed this case knows he was the lawyer that argued this case in front of the Ninth Circuit. In fact, if you watch or listen to the Ninth Circuit argument, none other than one of the appellate justices back then said rather astutely that they certainly looked like they changed the rules of the game between trial number one and trial number two.
Can you elaborate on those two pieces of evidence?
So the first piece of evidence was discovered approximately 9 years ago, and it was discovered in the personal effects of Andy Cano. Andy testified at the trial. Andy tragically died more than 20 years ago. His mother had kept his personal effects. When a reporter had gone to the house, they found the personal effects, and they found a letter that had been written by Erik prior to the killings. And the letter described the abuse at the hands of his father, Jose. And it's basically gut-wrenching. And it shows that in real time, there was what in the law we call, basically it was a pre-fresh complaint. It was a real-time cry to his cousin that corroborated the abuse that was going on.
And the other one?
The other piece of evidence is a declaration by a gentleman named Roy Rosello. Roy Rosello was part of the boy band Menudo. And Roy Rosello's declaration says that he was taken to the Menendez house and he was abused there. The reason that's interesting, just because you have a third party, is that of all the places in the world for this very successful record executive, Jose Menendez, to take somebody to abuse them, the one place he took them was the one place he felt safest, which was the house, the Menendez house. Brian can speak to this, but it was well known in the family that one of the rules was in that household that if one of the sons was there with their father in one of the rooms, that you were not allowed to go down the hallway. To me, that's a shocking rule, number one, and it's a shocking rule to be enforced, number two. But you have to understand, we were at a different time. I tell this story often. That roughly the same year that they were tried, I tried a case in Pomona with a woman on a battered woman syndrome. And we used that effectively to win her a voluntary manslaughter. The second trial, the judge ruled, and it may have been a correct ruling legally at the time, although it completely undercut the first case, he ruled that it was a battered woman syndrome and it did not apply to children. Imagine looking through the prism of today, saying that child abuse is somehow lesser than or less than or inferior to domestic abuse. You'd be laughed out of almost any courtroom I can think of.
So, Mr. Garagos, with this habeas filing for the Menendez brothers, what's your gut instinct? Do you believe that the sentencing will be set free?
Yeah, look, to understand what the DA talked about today, there's two options. They could either oppose the habeas and say, no, we want to litigate this. They could concede the habeas and say, give them a new trial. Or they could do what I think was basically said by Mr. Gascon, we're going to seriously take a look at resentencing. Resentencing means, under the present law in California, the judge would have the power to recall the sentence, to reduce it to a manslaughter, resentence them to time served. And by all accounts, both from the family and from everybody else, I think that there are millions of people who agree that is the right, that is the just result in this case. And so we're gratified that the district attorney has taken this seriously. We've said for the last 18 months, we've provided them with all kinds of materials. We've provided them with mitigation materials. They're working, both brothers are working on a green space project down at Donovan State Prison that I've personally gone there and seen, and is unbelievable. And mind you, what they will tell you is that 90-some-odd% of all people who are in prison in California get back out. So if you really want to do something, you need to do something to make sure that they're not part of the recidivism or the revolving door. Part of what they have put together is a green space project based on a Norwegian model that is mind-bogglingly recidivism, anti-recidivism. So they've done that. They've done great work there. We attended, both Brian and I attended Lyle's graduation from UC Irvine. There was a class of 20, the first ever class of 20 that graduated 3 months ago in the Department of Corrections under a joint program. If you're going to keep people housed or warehoused, if you will, in prison, then why not use the system to educate them so that they don't reoffend? And I don't think that there's anybody who at this point seriously concedes or entertains the idea that they would ever reoffend. Look, I think it was a very brave thing for the current district attorney, who was taking a lot of flack for a lot of his positions, to come out 30 days in front of a contested election and make the bold statements that he did. I was telling, I've been saying to anybody who would listen all day, previous administrations never, I can't even imagine or fathom any of the previous DAs coming out here 30 days before an election and even saying that they were going to take this seriously. So, yes, am I optimistic? I'm more than optimistic. I think they should be out. I think they should be out yesterday, but patience is a virtue.
Sorry,
and with, yeah.
Did you talk to Lyle and Eric? Are they aware that Gascon even came out and spoke today?
Yes, I believe that they're aware. I don't know how, I don't know whether it was in real time, reported afterwards, but there's a pretty good network of communication in the prison. Thank you. This is Brian Friedman, who represents the family.
Hi. Brian Friedman, B-R-Y-A-N-F-R-E-E-D-M-A-N. I represent the 24 family members of Lyle and Eric's family, and the matriarch of the family, Joan, and they'd like to, you know, they say enough's enough, and it's time. They've been in prison for 35 years. The entire family wants them out. They know who these boys are. They know that what good young men they are, and enough's enough. And we're pleased the DA came out today. We want the DA to come out stronger, and we're looking forward to the day that they can come back home to their family.
Right, can you talk about how those 24 family members signed something asking that they be released, and how the family members, I think, all but one have supported the brothers since the beginning?
Yes, the family has supported the brothers all since the beginning, and they've been together since day one, wanting them to be out, and have seen them in prison as they've grown up in prison. They've seen what model prisoners they've been. They've seen how they've acted, towards other prisoners, how they've acted with the Green Space Project. They've seen, who they are as people, and understand what happened to them, and understand, what happened with other family members, and just the time has come. Enough is enough. Our society has evolved to a degree where, when male-on-male sexual abuse happens, we have to stand up and say that that's equivalent, and that, that can cause pain. And that they believe that these boys should be resentenced. They should be let out. They will be model citizens, just like they were model prisoners.
That the jury back then was deferred, and that's cause for
Yes, yes.
Correct. There has been, and there is evidence that the jury didn't hear, both because of the rulings, number one, and number two, because it wasn't available at the time, which is why you have both the resentencing and the habeas. One of the other things that, for those who say, well, or push back, why now? This office has taken these allegations very seriously. Brian was present when we did what's called a conditional examination of Joan, who is the matriarch of the family, and the conditional exam, because she's in her 90s, she wishes for nothing more than them to be released, and we captured her testimony about that under oath on video so that there would be no question. The family wants to meet with the DA.
And Joan is Kitty's older sister. She's 92 years old. She might be 93 now. She's a lovely woman, and sat through that conditional hearing and unequivocally said, release those boys. Enough's been enough. The family's had enough.
And the letter that was found, Andy, that he's a cousin.
Andy is Marta Cano's son, and Andy testified. And the letter corroborates exactly what he had been saying. But it was not discovered. He's the cousin, first cousin. But it was not discovered until, I believe, 2015 or 2016.
Yeah, I don't think there's any question that the abuse went on and what type of abuse it was. It's time. Thank you.
Understanding that the family has always said, all right, the boy should be punished because even if you've been abused, you need to be punished. The family, I guess, has always maintained they should have gotten manslaughter, and what that would have been 11 years for Kitty, 11 years for Jose, 22 years total. They would have been out a long time ago had they gotten manslaughter.
Yes, they would have been out a long time ago. That's true.
But unfortunately, the second trial, they didn't have the option of manslaughter. If you can talk to that, they were only given the jurors the option of murder.
Yeah, Mark can talk to that better than I can.
Remember, what happened in the second trial was they were foreclosed in large part from presenting abuse. Now, the abuse, frankly, I will tell you, you could make the argument that negated the killings altogether, but that was not what they were trying to do. Leslie Abramson had effectively, when a jury, two separate juries, remember the first trial had two separate juries. Those separate juries deliberated separately, unbeknownst to one another. Both of those juries, when they heard the abuse evidence, found, fully half of them found not guilty on murder, and were going to convict on manslaughter. So the idea that in the second trial, you don't get to put on your defense, number one, and then number two, that the DA could argue in closing that there was no abuse and it was an excuse, and that the abuse excuse, and to mock them, and remember, they were mocked unmercifully during that time period, because nobody could wrap their head around the idea that this could happen. And that, to me, is the tragedy of this. And under no circumstances in a million years, if they had been sentenced and maxed out on manslaughter, would they have ever served 35 years. That's it. Thank you.
All right, you were just listening there to famed criminal defense attorney Mark Garagos, who represents post-conviction. He represents the Menendez brothers. You also heard from Brian Friedman. He is the attorney for the wider Menendez family. So wanted to make sure we got that in there as well. But you heard from both of them saying essentially they want this potential new evidence re-examined, brought to light, saying that these two brothers, they've been in prison for 35 years, that whatever comes of this new reevaluation of the case, that they deserve to be out. Friedman was saying that they will be model citizens, just like they have been model prisoners. And so this is a story we're going to have to stay on top of, all precipitated by this press conference given today by the Los Angeles County District Attorney George Gascon here, saying that he will review the case, review the sentencing as well. Don't know what's going to come of it, but it looks like the wheels are in motion here. So we'll have to stay with it. All right.